Court will note that this matter is before the court on the defendant's motion to cease and desist return of marital property in this matter. Mr. Osborne, you can proceed with your motion.
Well, Your Honor, thank you. I would just like to figure out how she's being able to take all our marital property and give it to other people, and I still haven't been able to get mine. It started off with the first time you granted me the motion in April, and Tiffany has changed the locks on the pole barn, and then I had 7 people with 7 trailers out there to try to get all my belongings, personal and business, and you granted me 4 hours. Well, I've got 38 years of stuff out there in the pole barn, and I have not still been able to get to it. 2 weeks later, after we found out that
Let me ask you that. As the court set a date on March 23rd, why didn't you get it at that time?
I didn't get it that day because Tiffany had changed the locks on the pole barn and told me that they were the same. Well, I had arranged 7 people out there with 7 trailers to try to get as much as I could in a 4-hour period, but she changed the lock, so I was unable to do that.
Your Honor,
hold on, ma'am. I'm letting him talk. Don't interrupt.
Okay. Sorry, guys.
Okay, so, well, if that's the case and you couldn't get in and get them, why did you wait now for basically, 8 months?
Well, I came back 2 weeks later to get the remains for my first time to go in there, and it had rained. Well, my property is on a hill and it sloped down, so I couldn't get half of my tools out there because the ground was wet. I didn't have concrete, so I got as much as I could, and then that was it. And then she told me that it was all gone after that. So the last time we spoke, you had granted me the right to go out there on November 8th, and I couldn't go out there because I can't get in contact with Tiffany, and she doesn't follow through with anything that the courts say.
Okay, sir, let me stop you. If the court orders you go out on a particular date, that's the date you go out. Okay? If you go out there and let's say she's got a lock on the building, then you cut the lock off and you go in and get your stuff. Okay?
Okay, I didn't understand that. I was supposed to go on the 8th, but I have no way to get in contact with her, and I didn't want to go out there because she's got a PPO, and all she's trying to do is get me arrested and convicted of hemmed up in some charges.
Okay, if you've got a court order saying you can go out there and pick something up on that date, that's going to supersede any PPO that might be in existence. So
I never got anything. Sorry, go ahead, Your Honor.
So all I'm saying is you got to comply with the orders, and if one party isn't complying, the other party still has to comply. And it says, okay, you're going out on a particular date, you go out on that date and you do what you have to do on that date. Okay. It's not a case where, okay, you go out on a date, well, geez, I can't make it, or it's raining or it's snowing or whatever it is, so I couldn't do it. That's the date that you're supposed to go out. And if it doesn't work, then you come back in the court and say, Judge, I couldn't go out for this reason. I need another date, and the court can set another date at this point. But you just can't not comply with the order and then come in and complain that the other party didn't comply with the order, because you didn't either.
I understand, Your Honor. I didn't have any paperwork because we were supposed to, I guess at the end of the judgment, I was supposed to get some kind of paperwork that Tiffany was supposed to fill out stating that this is what you came up with. You told her that she needed to do it. I still haven't received that, so I really had no paperwork to do that.
Okay, let me Ms. Osborne, what's your response?
Okay, he was a no-show. The barn was unlocked. He could have come and gotten his items, but he chose not to. That is not my fault. And what he's talking about, what happened in March, yes, I had it rekeyed, which I thought meant I had a duplicate to his key because I wasn't allowed out there. So I felt bad because he couldn't get in that weekend, and he arranged to come the following weekend, and he did. And he had several trailers take his things out, and I felt so bad about the first time he tried to retrieve his items that I let him in at least 10 times in that barn this summer, only to find out the last time that he was so comfortable coming and going, grabbing stuff from the barn, he put his own batteries in the keypad again. So I had to pluck the batteries out, lock it up, and then, every time he's contacted me, I've always let him come in and get his things, helmets, you name it. I mean, everything that's
Objection, Your Honor, that's just, that's not, that's,
I'm
that's
talking,
not
please.
true.
Sir, don't interrupt her. I told
Okay.
her not to interrupt you.
So
right, sorry.
he has come and gone multiple times, and I also have a video of him coming here and loading things from the barn up when he thought I wasn't home. And that was when I was picking Paisley up from school. He didn't think I was at the house.
Okay. Well, obviously, we want to get the things resolved as it relates. Let me ask, sir, are you able to get to the property on November 30th at 12 o'clock noon?
Yes, I should be able to.
Okay,
November 30th.
yep. It's the
May-
Saturday after Thanksgiving.
Yeah.
Your Honor, may I tell you that I'm a little nervous about whatever's out there. He's going to sell. He's not paying his child support properly, and he has broken the PPO and gotten a hold of me on
Well,
Thursday evening.
Okay,
And
well, let me tell you what happens is, again, either prior person, if either of you have sold marital property, you'll be accountable for that in the divorce action. So if, let's say, I don't know, let's say there was a table saw, and ma'am, if you sold that, you're gonna be liable for the amount of the cost for that table saw, or vice
No.
versa. I didn't
know.
ask you about whether, I'm just telling you an example.
Okay.
If he did it, he's gonna be responsible for the cost of that as well. So all I want to do is get the issues of personal property resolved if we can. So I'm going to order at this point, the last and final time, sir, on November 30, 2024 at 12 o'clock noon, you can get out to the property. I'll have ma'am make sure the property, the barn or whatever it is unlocked. If it's not unlocked, he has a right to break the lock off and get in there. And he
Yes,
can
sir.
get all the personal property. Ma'am, if you want to get in and make an inventory first and take picture, you have a right to do that. But what happens, I want to make sure that that gets resolved, and also order the parties, you can't dispose of anything just because it's in your possession. It's still marital property, subject to division by the court. So that will be the order. Sir, you're gonna have to do an order that's gonna say order that you have access on the November 30th date at 12 o'clock noon to get in, to get that personal property. And just do an order. You can submit under a 7-day notice of entry, and then you'll have the order this time when you go out there. Okay?
Thank you.
Okay. Free to go. Have a good day.
Thank you.
too.
Court will note the appearance of Ms. Podolsky. On behalf of the defendant, this matters before the court on the defendant's motion regarding parenting time, Christmas parenting time, tax issues, and other relief. Ms. Podolsky, you are still muted, so I won't be able to hear you.
There you go.
Okay, go ahead, you can proceed.
Thank you, Your Honor. It's starting first with the income tax exemption. The parties have language in their judgment of divorce, which states that the plaintiff will claim 1 minor child each year. Defendant will claim 2 minor children each year for the purpose of tax deductions on their federal, state, and local tax returns. And when their oldest is no longer eligible to be claimed, they will each claim 1 child. In the tax year 2023, plaintiff did not follow this provision in the judgment of divorce. She claimed all 3 children as income tax dependents. This caused my client great financial harm. This is something he relies upon, that he plans for. So we're asking the court to rectify this. We're asking that he be allowed to claim all 3 children as income tax dependents for tax years 2024, and then 2 children for tax year 2025. As it relates to this year's holiday parenting time schedule, and these 2 issues go hand in hand, my client is taking a trip to the U.S. Virgin Islands. He is taking the minor children with him. So we have outlined a proposed schedule for the 2-week holiday parenting time. That outline is in the motion. That is something that he has previously shared with his ex-wife. They just don't have a confirmation that those dates are acceptable. And so we're just seeking an order stating that he will have the minor children on those dates to be able to take that trip. Further, 2 of the children are under the age of 18. They do need passports. While they are traveling to what is the United States territory, we just want to make sure all bases are covered. If there's a flight that's diverted, if they have an opportunity to travel to, say, a British Virgin Island, which is very close to where they'll be staying, we think it would be appropriate for the children to have passports. My client is willing to pay for the cost of those passports for those 2 minor children. And then they would also be available to Ms. Adams whenever she would want to travel out of the country with the minor children. Lastly, Your Honor, as it relates to parenting time, the judgment of divorce does provide a schedule wherein Ms. Adams has the minor children 8 out of a 14-day period, with my client having the minor children 6 days in a 14-day period. They do have a specific provision regarding summer parenting time where each party is able to have 2 weeks of vacation time, and they have to let the other party know in writing 45 days ahead of time. Their other schedule is then exercised year-round. At this point, Your Honor, these children are 16 and 13. As I stated before, the parties do have an 18-year-old. The initial idea behind this schedule was the children were very young when the parties divorced. And there was actually language in the judgment that said they would specifically meet in no later than September of 2016 to look at modifying that schedule. When my client approached Ms. Adams about it, she said, nope, we're not making any changes. So we do believe her agreement to that provision was disingenuous at best. But now we've got a 13 and 16-year-old. They go back and forth between these parties' homes 4 times in a 2-week period. This is a difference of 25 overnights in a calendar year. They have asked repeatedly for a week on, week off schedule. So we're just asking the court to make that slight change, week on, week off, year round. That would then alleviate the issue of summer parenting time and having to make that request 45 days in advance. The parties would each know what weeks they would have the children. They can schedule trips. They don't have to then worry about maybe interrupting time with the other party. And then with that, we just request that the court update the holiday parenting time schedule, as the Calhoun County holiday schedule has changed significantly since the parties were divorced. As the court knows, we now have longer weekends at Thanksgiving, Labor Day, and Memorial Day, and we would just like that incorporated in the new schedule. Thank you.
Thank you. Ms. Adams, what's your response?
Yes. Hi, good morning.
Good news.
I just wanted to state that this is all a little bit of a surprise to me. I opened this paperwork on Thursday evening, and I honestly had no idea that there wasn't any attempted discussions from Mr. Adams on some of these things that he's seen as unresolved or questionable. As far as my recollection and understanding, well, where would we like to start off? I guess I'll start in order, and I'll answer the first part, which is regarding the tax relief.
Okay.
So it was brought to my attention years ago through seeking legal counsel and counsel from multiple accountants that according to the IRS tax law, whoever the children reside with more than 50% of the time.
Okay, ma'am, let me interrupt you there. That's true. The IRS code does provide for that unless there is a subsequent or a different order as it relates. In this case, you had a judgment that did provide for different handling of that deduction. So the IRS code is not applicable in this matter.
Okay, so that is definitely something that is different from what I had been told from legal counsel as well as accountants. So yes, if that's the case, then I have been misinformed. And also, just to let you know, the supporting, there's additional reasons why I thought this was to be true was that Mr. Adams had approached me years ago with a document from his tax accountant asking me to legally sign off that he could claim 2 dependents. So I thought, why would I need to sign off this if the judgment of divorce is true and honorable and stands? So that was another reason that led me to believe this would not stand. Okay.
Go ahead. Go further.
Okay. So again, so what I had done is I attempted to have conversations with Mr. Adams to work something out with him. And I thought that what would be more than fair was that we would alternate the years that each of us would claim 2 children. So I attempted to have that conversation with him. Mr. Adams thought that was not, that he was entitled to claim 2. Even though he did make more, has a higher income. I was starting my own business, trying to get my business off the ground. I do have, lesser income. So all of these factors, I thought, according to the IRS tax law, if it states that the custodial parent, whoever has them 50% of the time, should claim the children. I felt in my eyes I was being more than fair by offering to alternate those exemptions and as the dependents. And
Okay, well, let me address that. As I stated, the IRS code is not applicable whether there's a judgment in place. So the court does note that the plaintiff in 23 claimed all three children when she was not entitled to claim all three children. As a result, the court is going to grant the motion as it relates, allowing the defendant to claim all three children in 2024, and then the two children in 2023, which would allow him and make him whole based on losing the exemption in 2023. Do you have any issues as it relates to the trip to the Virgin Islands, ma'am?
no, I don't, Your Honor. I was surprised about this because we had correspondence via email about the trip, and I did not state that he could not get passports for the children. But what I did express was that I had basically stated that if he does obtain passports, I was just letting him know that I'm giving approval for him to take the girls to the US Virgin Islands, but that I wasn't giving automatic approval for any future travel to any island or overseas that does not work with or cooperate with the US. That was what I had stated.
Well, that's already in your judgment. That's a provision under the Hague Convention that doesn't allow the person to take the children to a country that does not, and is not a signatory on that particular convention treaty. So that
Yep.
we don't have to include that. The court will grant the request that he has the children from the December 27th, 2024 to January 4th, 2025 for purposes of taking him to the Virgin Island, as well as that he is able to acquire the passports for the children.
That's not a problem at all, Your Honor. The
Okay.
only question that I have in regards to that is the return, on the dates of the return and when the children would return back to me. That was questionable, and there was a confusion as to how that was written. So.
Well, we'll have Ms. Podolsky include that in the order then. So it's clear. The last thing would be the relates, well, two things actually, the holiday parenting time, that's changed pursuant to the front of the court practice, if you would. Is there any problem with modifying and changing that to the current practice?
No, I don't have any issues with changing that and modifying it. The only thing that I had noticed is that as it relates to Thanksgiving holiday this year, that would cause a little bit of an issue just because we had already had a family plans and party set on the day after Thanksgiving. So that would actually be a little bit of an issue right now to change. But moving forward, there's no concern whatsoever on that. I just would like some clarification on when those things are stated out for the parenting time holiday schedule, that those apply to both parties.
They do.
Okay.
They alternate. So again, if you had Thanksgiving this year, you wouldn't have Thanksgiving next year because it would alternate.
Correct. Can I just ask a quick question and clarify what my concern on this and give an example for what I'm referring to? Because there has been an issue, and I will just explain what it is.
Well, I don't need, if we're changing that and alternating it, I don't need a rendition of something that previously happened because it wouldn't be applicable now. So
the only thing I would like clarification on is when it states, for example, a Father's Day holiday ends at 6 p.m. Does that mean that the children come back to me at 6 p.m. even if it's his standard parenting time? Or that's the question that I have, and I think that's where the confusion lies.
well, the specific times, those take precedence over other times. So let's say your weekend was the weekend of Father's Day and he has Father's Day, then that would take precedence over your time.
Correct. So I guess again, I think where things have been muddied is that Mr. Adams has Sunday, Monday overnights standard for the children. And a lot of times that's where the holidays fall. So it gets it's getting complicated. I just would like some
No,
clarification.
it's not complicated. What happens is the specific parenting time takes precedence. So if it's his weekend, but let's say, for instance, you have, I'll just throw Memorial Day. You get Memorial Day, notwithstanding the fact that it's his weekend, because that takes precedence.
So for example, if he has the kids overnight on Father's Day every year, the Father's Day does not stand for him because it says return at 6 p.m. Is that true?
No, the Father's Day
Okay.
would be his Father's Day regardless.
Mhm. So even though it says 6 p.m. as an end time, it's not true and they would spend the night. I just want to verify it. Am I understanding that correctly?
Well, it depends on what the holiday is and what the next holiday would be. So,
I guess I would like to just state, we have not had issues, in my opinion, on any of the holidays and how they're stated. However, Mother's Day and Father's Day just seems to be an ongoing issue. He's always had the kids overnight for Father's Day because it's a standard evening, standard parenting time, but I've never been able to have them. And it's always been an issue and a fight to get the girls back on Mother's Day. So I just wanted to know if that was something.
on Mother's Day, you would be entitled to the time set forth in the order as it relates to the Mother's Day parenting time.
Okay, and am I allowed to ask for an overnight request 45 days in advance?
Well, that wouldn't be provided for under the order. You can ask for anything you want, but
Okay,
again, it's not, it doesn't apply. So if he denies that, then you wouldn't have him overnight on that day.
okay, so he just happens to get them overnight since it is his
Correct,
night.
correct,
Okay, I
correct.
just wanted to make sure I was understanding that properly. Okay,
Okay. And what's the last thing is the request for, again, to modify, to change the parenting time to be alternating weeks rather than the schedule that's in place now.
Yes, Your Honor, this is the first time this has come up.
Okay, I don't care if it's the first time or the 10th time, I'm just asking you what's your response?
Yeah, no, my response is that I don't think that it would be in the best interest of the girls at this time, since they have been consistently doing this for 9 years, to go ahead and change that up. And there has been no request or conversation at all from the girls to me, any type of communication about wanting to change the schedule.
Okay. Well, it does appear that the schedule when it was implemented was obviously could be related to their age and not having to have them gone such an extended time. But the court does note in reviewing the motion that in fact it does provide obviously not the consistency that could be provided on a straight schedule. And it requires that the kids would, again, be disrupted a number of times during the 2-week period, going back and forth. So the court is going to grant the request at this time. If there was, again, some problems in the future as a result of it, then I'll say, Ms. Adams, you have a right to file a motion. The court can address it at that time. So,
Okay,
Ms. Podolsky, I'll ask that you would prepare an order and submit it under 7-day.
Thank you.
Okay, thank you. You're free to go. Have a good day.
Thank you.
Thank you.
This matter is before the court on the plaintiff's motion to set aside the referee recommendation in this case. I would state, Ms. Adams, for your purposes, be aware, you stated in your motion that I disagree with the referee's findings and recommendations. Your disagreement is not a basis to set aside the referee recommendation. You have to establish that the referee made a factual or legal error in the particular case. So what is the factual or legal error that you're contesting?
Due to the fact everything else that's going on underlying this case, this whole case,
okay, that doesn't tell me anything. Everything else that's going on I have no idea what you're talking about.
I apologize, Your Honor. That's why I've sought out to an attorney now, because I don't know how to present evidence and I don't know how to
Okay,
file these motions.
okay. That's fine. But again, what factual or legal error did the referee make that should, again, cause the court to set aside his findings?
Your Honor, this is why I've sought out an attorney now, due to this matter, because the underlying issues are, he was under investigation for, child pornography and abusing our daughter. And there's a lot of things that were not, correctly stated in the investigation,
Okay.
on Mr. Curtel's part. So, like I said, I don't know how to present the stuff correctly. That's why I've sought out an attorney.
Okay, well, what I'm gonna do at this point, because you have not come up with any factual or legal error made by the referee, you've got other issues. What the court's gonna do is, the court's not been presented with any basis to set aside. I'm gonna deny the motion, and you can file whatever motions you want with your attorney to challenge anything in the case. But again, there's nothing, nothing submitted at this point that would entitle the court to, again, set aside the referee. So I'm going to deny that. So that will be the order. You're free to go. Have a good day. This matters before the court on your objection to the referee order. I've looked over a lot of the orders in this case from prior orders in this particular matter. And first thing I note is in this file, you had not filed a proof of service showing that you served the defendant. Did you serve the defendant?
Yes, he got the letter because he messaged me about it.
Okay, that's not what I'm asking. He can message you. He can do anything he wants.
I served him.
saying-
Here's the proof. I asked the court if they needed this proof, and they said no.
Now, the court, you always have to file a proof of service showing you're serving the pleadings in this matter. So
I had a signed copy from the clerk that I served it.
okay, that signed, why would you get a signed copy from the clerk? That doesn't mean anything. The clerk didn't sign it, so I don't know what you're saying.
I don't know. They said to send it certified mail. Here's my receipt from the certified mail. I'm not sure what else you want, Your Honor.
A proof of service. There's something called a proof of service that shows that you served it. You basically swear to that before a notary, and that's what the court is looking for.
I have this piece of paper that says objection to referee's
Okay.
recommended order. The lady said, fill all this out, go to the post office, send it certified mail. I did that. I came back to the courthouse, to the clerk's office, and she said, okay, and gave me a date.
Okay, but there's no proof of service. So from the standpoint of the file, we don't know that there's been service because you haven't filed a proof of service confirming that there was service.
They never gave me anything else to fill out.
They don't have to give you that. When you represent yourself, you have to file the same paperwork as if an attorney would, if the attorney was filing the case. And one of those things you have to do is file a proof of service showing that there was service on the other party. So what I'm going to do is, obviously we don't have the defendant here, so I don't know if the defendant was served or not. And the file doesn't establish that he was served. So I can't just assume that he was served. So what I'm going to do is I'm going to have you put this matter over. You're going to have to renotice the matter, giving him sufficient notice, and then file a proof of service. And you can get on michiganlegalhelp.org or any number of online services that simply would have the pleadings that you need to file as far as a proof of service, establishing that there was service. That way, when we grant any relief, we know that the other party did get notice of that. So,
Okay, so this all started because I went down after getting a letter in the mail.
okay, I don't need to know any of that information. You need to get a
I'm
new
just trying
date.
to find out why it's $3 a month for the payment.
Again, I'm not getting the specifics because we don't have service, ma'am. And when we have service, then we'll be able to get into the specifics of what happened and why it occurred. I look
Can
back
I
through
ask
the
a
file.
question?
Go
I'm
ahead.
sorry for interrupting. How would I find out what happened at the last show cause hearing?
You can get a transcript. You can order a transcript and that will be the entire proceedings.
Okay,
Okay? We're at
Thank
this
you.
point, the court will just set this matter over. You can renotice it and get service on the defendant, and then we'll address it at that time. Okay? Have a good day, ma'am. This matter is before the court on the plaintiff's motion to opt out of front of the court services. I assume, Mr. Swank, you do not have any objection to that?
Not at all, Your Honor.
Okay. Ms. Swank, in this matter, I'll let you know that, again, if you opt out of front of the court services, you'll not have any assistance in enforcing any of the orders that exist in the case. You understand that?
Yes, I do, Your Honor.
You have a right to at any point at any time, a week from now, a month from now, a year from now, whatever, you have a right to go again, notify the front of the court and then seek to have the front of the court involved in the case. You understand that?
Yes, I do,
Okay.
Your Honor.
Okay. Court will approve and sign the order opting out of front of the court services. And again, you have no inclination, no requirement that you do so, and you can change your mind at any time. And as long as you're aware of that, that's fine. We'll sign that. You're free to go. Have a good day.
Thank you, Your Honor.
Brooke Edwards versus Gregory Edwards. Today is Monday, November 18th, 2024 at 9:02 a.m.
Court will note the appearance of Mr. Veenheis on behalf of the plaintiff in place of Ms. McNiff. I guess, Mr. Hauser, you're appearing as a observer, I guess?
No, Your Honor, there was both a notice of appearance and a answer to the motion filed late in the day Friday.
Okay.
So here on behalf of Mr. Edwards.
Okay, thank you. The court, I haven't received that yet, so front of the court wanted to keep it a secret from me, I guess. Okay, Mr. Veenheis, you can proceed on your motion to prohibit contact between the children and Miss McKediak.
Thank you, Your Honor. This is a motion to prohibit contact between the children and Summer McKediak, Your Honor. Miss Attorney McNiff has listed a number of reasons as to why contact between the children and Miss McKediak should be prohibited. If the court looks to the motion, there were allegations and then ultimately charges of fourth-degree child abuse. A deal was worked out, and it seems that Miss McKediak was placed on probation for those offenses, or at least one of those offenses. According to the answer that was filed by Attorney Hauser, she has since been discharged from probation for that, but that the fact still remains, Your Honor. There's other allegations contained in the motion of other charges and criminal convictions here in Calhoun County. And if the court's read the motion, they know what those are. Ms. McKediak is not an appropriate person to be in contact with the children. And for those reasons contained in the motion, Your Honor, we would ask that the court prohibit contact between the parties' children and Summer McKediak, as has happened previously with Mark McKediak, Your Honor.
Okay, thank you. Mr. Hauser, what's your response?
Yes, thank you, Your Honor. We would object to the motion as it relates to the child abuse charges as stated. That matter has been resolved since the time of those events. There have been no new allegations brought forth. To the best of our understanding, everything has been going well. The victim in that case, in the child abuse case rather, is now in the custody of Ms. Summer McKediak, and all has been going well there. So we would ask for the motion to be denied. and for contact to continue as it has been, which it's my understanding that contact between Miss Summer McKediak and the minor children here is pretty limited. It's my understanding that Mark June Jr., Summer McKediak's minor son, and Mr. and Miss Edwards' minor son have developed a little bit of a friendship during the time that Summer's children were residing in Brooks' home. So with that limited contact and the friendship of the minor children, we just would ask for things to remain the same. And obviously, if there's any future concerns, those can be brought forth at any time. But there is no alleged misconduct here between Summer McKediak and the minor children in this case.
Okay, thank you. Well, the court will start out with noting that, again, the third party doesn't have a right to have contact in any particular case. So in this matter, as Mr. Veenhuis has pointed out I don't want to get into all of the issues, but in the motion, Ms. McNiff has, again, delineated why it's not appropriate to have contact. I understand that, again, with regard to Ms. McKediak, that those pursuant to a plea agreement, that the charges were subsequently dismissed after, again, a period of probation. But in this matter, the court, again, goes from the premise that third parties don't have any inherent right to have contact with the children. And it's plaintiff has set forth some basis for the court to not allow that. And as a result, what the court will do is the court is going to order that Ms. McKediak would not have any contact with the children in this case until further order of the court. And I'll ask Mr. Veenhuis that you would have Ms. McNiff submit that order under 7-day notice of entry.
Yes, Your Honor.
Okay, thank you all. You're free to go. Have a good day.
Thank you, Your Honor.
Thank you.
Thank you, Honor.
Summer McKediak versus Mark McKediak. Today is Monday, November 18th, 2024 at 9:28 a.m.
Court will note the appearance of Mr. Hauser on behalf of the plaintiff and Mr. Magnuson on behalf of the front of the court. The front of the court has filed a motion to set aside the consolidation ordered by the referee in this matter. Obviously, setting it aside only to the extent they have the consolidation occur at the time of the entry of the judgment of divorce. Mr. Hauser, do you have any opposition to that?
No, Your Honor. As relates specifically to the consolidation component, we take no position.
Okay. Mr. McKediak, do you have any problem with that consolidation not occurring until the entry of the judgment of divorce?
No, I do not, Your Honor.
Okay. Well, with that, Mr. Magnuson, it looks like you don't have any opposition. The court will grant your request. You can submit an order in this matter saying that the consolidation will occur or be included at the time of the judgment of divorce and not, and again, that the court will again set aside the consolidation that's contained in the referee's order.
Yes, Your Honor. I'll prepare that order. Thank you.
Thank you. Have a good day. You're free to go.
Thank you.
Thank you.
Kelsey Daniel versus Edward Daniel. Today is Monday, November 18th, 2024 at 9:30 a.m.
Court will note the appearance of Mr. Magnuson on behalf of the front of the court. The front of the court has filed a motion to set aside the consolidation of cases as contained in the referee's order in this particular matter. Ms. Kelsey, Ms. Daniels, do you have any problem with the consolidation occurring at the time of the entry of the judgment as opposed to the current time?
And what do you mean? I'm confused. I'm sorry.
Well, the referee had consolidated this case with a prior DS case, and the front of the court is saying, well, it shouldn't be consolidated until we have a judgment, because again, if you do consolidate it at this time, and then let's say the divorce matter got dismissed or something of that nature, you'd be dismissing the other case as well. So that's all they're saying is procedurally is we'll include it at the time of the judgment of the divorce.
Okay.
Okay. Well, sounds appropriate to do, Mr. Magnuson. So as in the last case, the court will grant your motion and provide that the consolidation would be included in the judgment, but vacated as it relates to the referee's order.
Very good. I'll prepare that, Your Honor.
Okay, thank you. Have a
Thank
good
you, Your
day.
Honor.
You're free to go. Court will note that this matter is before the court on the defendant's motion to set aside the default. Defendant had stated in this particular matter that he was under the impression that the parties could resolve matters amongst themselves, and that he thought at one point that they had reconciled. Obviously, that didn't occur. Is there anything else, sir, as it relates to your motion? Mr. Trice, anything else?
No, Your Honor.
Okay. Ms. Trice, do you have any response?
No, Your Honor.
Okay. Well, what the court will do is the court will find that, again, being under the impression that they would resolve issues, especially the fact that this case is now 297 days old. So it's not like the case was filed and then on the 29th day, the person tried to enter a judgment, et cetera. We've had months and months when Mr. Trice could have taken action, didn't. Plus, the fact is, being under the impression that they'd resolve it is not a good cause to set aside a default. So the court is going to deny the motion to set aside default. However, the court would allow Mr. Trice to be involved for purposes of mediating and trial of disputed matters in this case, especially as it relates to any child-related issues, et cetera. The court will, in this matter, order, however, that the parties would mediate the case in January 2025. I'm putting it on a short time schedule because, again, case is so old at this point. We'll set it also for trial in February of 2025 so that the matter will, again, get resolved quickly if we're not able to come to an agreement. I'll ask Mr. Trice, is there anyone that you recommend as it relates for mediation purposes?
No.
Okay. Ms. Trice, is there anyone that you have would recommend?
Not at this time, Your Honor.
Okay. Okay. The court will simply then leave that up to the mediation clerk. She'll assign a mediator. The mediator will then contact you, and it'll be up to you to, again, schedule the date in January. Because of the fact that we're on such a short schedule, the court will state if the matter doesn't get scheduled in January because a party can't work it into their schedule or whatever, the court will still go through with a trial in February. And so we will send you a notice as to a trial date in February. And Mr. Trice, because it's your motion, you're going to have to, in the order, you're going to have to deny your motion to set aside the default. And the also would allow you to participate in mediation and trial of disputed matters. So it'd basically be a couple paragraph order in this matter, and you could just do it as an order after hearing. That's oftentimes what they call them, order after hearing, denying the motion and allowing your participation for mediation and trial on disputed matters. Okay, anything else, Mr. Trice?
No, Your Honor.
Okay, Ms. Trice?
Your Honor, to make sure that I understood you clearly, and just to clarify, so mediation will be in January of 2025. If we were not able to reach mediation, then what exactly
The matter will go to trial. If you reach an agreement, then that settles it and we can enter it pursuant to whatever that agreement is. If you don't come to an agreement or the matter is not mediated or not settled, then the matter will go to trial. So the trial date is a backup date in the event that everything else isn't successful.
Okay, thank you, Your Honor, for the clarification.
Thank you. Free to go. Have a good day.
You too, thank you.
Thank you, Your Honor.